Good afternoon once again. Unfortunately, our lecturer for today won't be able to join us virtually, but she was able to prepare a video presentation for today's lecture. Our lecturer is the Dean of the Ateneo de Naga University College of Law. She is a dual qualified lawyer in the Philippines and in the state of New York. She obtained her Juris Doctor with honors from Ateneo de Manila University and her Master's of Law with graduate certificate in Business Law from the University of Southern California. She is also the Southeast Asia Regional Lawyer of the Global Climate Legal Defense and a trustee of the Climate Action and Human Rights Institute. She was a former head executive assistant of the Department of the Interior and Local Government, former commissioner of the Housing and Land Use Regulatory Board, former director of the Housing Finance Corporation, and former consultant at the Commission on Human Rights. She teaches political law, civil law, commercial, and remedial law review subjects in various law schools in the country and is currently the Secretary General of the Philippine Association of Law Schools. Please welcome our lecturer for today, Dean Domnina T. Rances. Let's watch this video.
Hello. Good afternoon, everyone. It's a real pleasure to be a part of your bar journey. And with just a month to go, I know that you must already be feeling the nerves, but don't worry, we here at Pals got you. So for today, I will be discussing 20 recent cases in political law. These are cases from 2020 until the bar cutoff of June 30, 2022, which I believe every bar examinee should be familiar with in order to conquer the bar. But before I begin, just a quick disclaimer. The images in my PowerPoint are not my own, and I merely grabbed them from Google Images for educational purposes. No infringement of any kind intended. Now let's dive in. We start with a case on state immunity, which is a favorite bar exam topic. This is the case of BPI versus Central Bank of the Philippines, now Bangko Sentral ng Pilipinas, decided by your bar chair. Notice in the picture of the BSP are the words pilferage scheme. This is my key phrase or keywords to help me recall the facts of the case. So in here, BPI is a member of the clearinghouse established and supervised by the CPB. It maintained demand deposit balances with the CPB for their clearing transactions with other commercial banks forced through the said clearing facilities. One day, BPI Lawag City branch discovered outstanding discrepancies in its interbank reconciliation statements in CBP in the amount of 9 million pesos. So BPI filed a letter complaint before the CBP on the alleged irregular charging of its demand deposits account. Upon investigation by the NBI, it was found that there was an organized criminal syndicate within the CBP perpetrating bank fraud through a pilferage scheme. It was later found out that it was CBP's bookkeeper, Valentino, and CBP janitor, Estacio, who were perpetrating this pilferage scheme. So thereafter, BPI filed a complaint for sum of money against CBP on the ground that CBP as employer is liable for the damage caused by its employees. CBP claimed immunity from suit. In resolving this dispute, the court began by discussing the concept of state immunity. It said that one of the generally accepted principles of international law, which we have adopted in our Constitution, under Article 16, Section 3, is the principle that a state may not be sued without its consent, which principle is also embodied in the 1935 and 1973 constitutions. However, as we all know, state immunity may be waived expressly or impliedly. Express consent may be embodied in a general or special law. On the other hand, consent is implied when the state enters into a contract or it itself commences litigation. In the case of government agencies, the question of its suability depends on whether it is incorporated or unincorporated. unincorporated agency has a charter of its own with a separate juridical personality, while an unincorporated agency has none. In addition, the charter of an unincorporated agency shall explicitly provide that it has waived its immunity from suit by granting it with the authority to sue and be sued. This applies regardless of whether its functions are governmental or proprietary in nature. So again, when confronted with the question of state immunity of government agencies, the first thing that you should ask is whether the agency is incorporated or not. If it's incorporated, look at its charter, whether it has the authority to sue and be sued. If it has that authority, then that is already express consent, regardless of the functions that it is performing. But if it is unincorporated, that's the time that you would want to look into the function and whether the act done, that is the subject of the suit, was performed by the agency in the exercise of its governmental function or whether it is merely proprietary. Here, CBP is an incorporated agency. It is a government corporation with its own charter, which provides it with the authority to sue and be sued. So CBP is not immune from suit as it has already waived its immunity via special law, which in this case is its charter. However, although CBP allowed itself to be sued, it did not necessarily mean that it conceded liability. While BPI had been given the right to bring suit against CBP, this is subject to the right of CBP to interpose any lawful defense. And CBP's defense is that it is not liable for the acts of its bookkeeper and janitor because those employees are not special agents. To understand this defense, we look into the rule on liability of the state for acts of its employees. On this level, the test of liability depends on whether or not the employees acting in behalf of CPP were performing governmental or proprietary functions. The state, in the performance of its governmental functions, is liable only for the tortious acts of its special agents. On the other hand, the state becomes liable as an ordinary employer when performing its proprietary functions. It is on this level that it is important to distinguish whether the government agency is performing governmental or proprietary functions. So, what is the nature of CBP functions? The court here held that it is governmental. Indeed, the function of CBP in supervising the monetary and banking systems of the Philippines is a governmental function, and part or parcel of that is the provision of clearinghouse facilities. Now that it is already established that it's performing governmental function, the next question to answer is whether the employees involved are special agents, because as we've said, that in the performance of governmental functions, the state is only liable for the acts of its special agents. Special agents are those who receive definite and fixed order or commission foreign to the exercise of the duties of his office. For example, if the bookkeeper is commissioned by the government to be a special liaison officer to the office of the president, then that would make the bookkeeper as a special agent. But if he is merely performing the functions of a bookkeeper, then he is not a special agent. Evidently, both Valentino and Estacio are not considered as special agents of CBP during their commission of the fraudulent act against BPI, as they were regular employees performing tasks pertaining to their offices, namely bookkeeping and janitorial work. Thus, CBP cannot be held liable for any damage caused to BPI by reason of Valentino and Estacio's unlawful acts. But even assuming, for the sake of argument, that CBP is performing proprietary functions, still it cannot be held liable because Valentino and Estacio acted beyond the scope of their duties. If you recall, Article 2180 of the Civil Code provides that an employer shall only be liable for damages caused by their employees acting within the scope of their assigned task. An act is deemed an assigned task if it is done by an employee in furtherance of the interests of the employer or for the account of the employer at the time of the infliction of the injury or damage. Obviously, Valentino and Estacio's fraudulent acts of tampering with and pilfering of documents are not in furtherance of CBP's interest, nor was it done for its account, as these acts were unauthorized and unlawful. We must always remember that where a public officer or employee acts without or in excess of jurisdiction, any injury or damage caused by such acts is his or her own personal liability and cannot be imputed to the state. Now, let's go to the Legislative Department and examine this case of Lagman versus Executive Secretary Ochoa, not to be confused with Lagman versus Executive Secretary Medialdea, which was about martial law. This case with PS Ochoa is about the GCG, or the Governance Commission for GOCCs, created by the GOCC Governance Act of 2011. It is alleged in this case that the legislature does not have the power to, one, pass a law shortening the term of GOCC directors, two, pass a law creating an executive agency that will determine whether a GOCC shall be reorganized or abolished, three, pass a law creating an executive agency that functions the same as the Civil Service Commission. Now for the facts of the case. In 2009, congressional inquiries into the activities of some government-owned or controlled corporations revealed several excesses and inefficiencies that drained government finances. Some of the uncovered excesses and inefficiencies involve the obscene bonuses received by the board of directors of some GOCCs, despite them being under poor financial condition. Certain GOCCs were also found to be implementing excessively generous retirement schemes, most notably in the Manila Economic and Cultural Office, where directors could retire after only 2 years of service at the rate of 600,000 pesos per year of service. Wow! So to address these abuses, RA number 10149, or the GOCC Governance Act, was signed into law. This law created the Governance Commission for GOCCs, or Governance Commission for short. It is an agency attached to the Office of the President. It is empowered, among others, to evaluate the performance and determine the relevance of GOCCs and to ascertain whether these GOCCs should be reorganized, merged, streamlined, abolished, or privatized in consultation with the department or agency to which they are attached. Representative Edsel Lagman filed a petition assailing the constitutionality of this law. He claimed that since the law unduly delegates legislative power, it infringes on a legislator's prerogatives, powers, and privileges, thus giving him locus standi to file the petition. However, this argument was rejected by the Supreme Court. It said that there is no encroachment of legislative power here because what is assailed is itself an enactment of Congress. This contradicts any prima facie notion of usurpation of legislative power, since it was the legislature itself that made the question delegation of powers to the executive. This must be distinguished from other cases where legislators questioned executive acts that allegedly usurp congressional authority or legislative prerogatives. Here, there is no executive act, but rather it is the legislative itself that is allegedly and duly abdicating its own legislative powers to the executive. Nobody here is impairing the powers or prerogatives of Congress. And just because a law was passed against the legislator's wishes, it doesn't mean that that legislature can already go to the Supreme Court and claim an impairment of legislative prerogatives. Clearly, Lagman does not have standing. But because of the paramount public interest, the court still proceeded to resolve the issues in this case. Lagman contends that Section 17 of RA 10149, which shortened the fixed terms of incumbent CEOs and appointed directors of GOCCs with original charters, violates their constitutionally guaranteed right to security of tenure. Section 17 actually provides two changes. One, each appointed director's term of office shall be for 1 year unless sooner removed for cause. And two, all incumbent CEOs and appointed board members of GOCC shall have a term of office until June 30, 2011, unless, of course, sooner replaced by the president. The Supreme Court here held that these changes are constitutional. It said that since the creation of a chartered GOCC is purely legislative, Congress then has the power to modify or abolish it, as well as to enact whatever restriction it may deem fit for the public good. Must remember that this law was enacted precisely to address reported abuses in the remuneration scheme and efficiencies in the operations of GOCCs. Public interest warrants the term reduction, shortening the term of directors to 1 year allows for a yearly evaluation of their performance and promotes accountability for public funds. Enacting RA 1149, including the shortening of terms of appointed directors to 1 year, fulfills what Congress had considered a great public need at that time. Thus, the legislature may, in good faith, that's the operative word, good faith, change the qualifications for and shorten the term of existing statutory offices, even if these changes would shorten the term of an incumbent. A public officer's right to security of tenure cannot be invoked against a valid legislative act resulting in separation from office. Shortening the term of office is not the same as removing the officer from service, even though both will result in the termination of official relations. When an officer's term is shortened, one is separated from service when the term expires, unless an officer is authorized by law to hold over in their position, their rights, duties, and authority as a public officer must ipso facto cease upon expiration of their term. Removal, on the other hand, entails the separation of the incumbent before their term expires. Clearly, Congress can, for legitimate purposes, reduce the terms of officers of GOCCs with independent charters. Now we go to the issue of non-delegability. Lagman contends that RA 1149 invalidly delegates to the Governance Commission the exclusive power of Congress to reorganize and abolish public offices. He claimed that such power cannot be delegated, and if it were so, the law places no sufficient standard to guide the Governance Commission in exercising this power. We all know that there are two types of permissible delegation of power: contingent legislation and subordinate legislation. Congress undertakes contingent legislation when it delegates to another body the power to ascertain facts necessary to bring the law into actual operation. Meanwhile, subordinate legislation entails delegating to administrative bodies the power to fill in the details of a statute. Here, what we have is contingent legislation, where GCG will ascertain facts in order to determine whether the GOCC concerned should be reorganized or abolished. Now, how do we know whether the delegation is valid? Two tests determine the validity of delegation of legislative power. We have first the completeness test, and second, the sufficient standard test. A law is complete when it sets forth therein the policy to be executed, carried out, or implemented by the delegate. It lays down a sufficient standard when it provides adequate guidelines or limitations in the law to map out the boundaries of the delegate's authority and prevent the delegation from running riot. To be sufficient, the standard must specify the limits of the delegate's authority, announce the legislative policy, and identify the conditions under which it is to be implemented. The law in this case meets both tests. The policy of the law, as stated therein, is to rationalize and monitor centrally the operations of GOCCs in order for government assets and resources to be used efficiently. Thus, the law is complete. It also sets therein the standards when abolition or reorganization of GOCCs would take place, like when the functions or purposes for which the GOCC was created are no longer relevant to the state or no longer consistent with the national development policy of the state. Two, the GOCC's functions or purposes duplicate or unnecessarily overlap with functions, programs, activities, or projects already provided by a government agency. Three, the government is not producing the desired outcomes or no longer achieving the objectives and purposes for which it was originally designed and implemented, and or not anymore cost efficient and does not generate the level of social, physical, and economic returns vis-a-vis the resource outputs. Fourth, the GOCC is in fact dormant or non-operational. Five, the GOCC is involved in an activity best carried out by the private sector. And six, the functions, purpose, or nature of operations of any group of GOCCs require consolidation under a holding company. Thus, here we can see that the law meets the sufficient standard test. What was actually delegated is just the power to ascertain the factual determinants for abolishing or reorganizing GOCCs. In this sense, the Governance Commission merely acts as an investigative body on behalf of Congress. Finally, we go to the last relevant issue. Lagman contends that the Governance Commission has supplanted the constitutional mandate of the Civil Service Commission by removing the chartered GOCCs from the jurisdiction of the CSC and placing them under the Governance Commission. The court disagreed and gave an enumeration of the distinctions between the functions of the Governance Commission and the CSC. It might be good to memorize these distinctions. First, the Governance Commission is focused on GOCCs as public institutions. The Civil Service Commission, on the other hand, is focused on the management of government personnel. Second, the Governance Commission's powers are limited to GOCCs and their board of directors and trustees, while the Civil Service is given the comprehensive mandate to administer the civil service and to render opinions and rulings on all personnel and other civil service matters. Third, the Governance Commission was created to act as a central advisory, monitoring, and oversight body that formulates, implements, and coordinates policies to evaluate the performance and determine the relevance of GOCCs. On the other hand, the Civil Service Commission is the government's central personnel agency that determines the qualifications of merit and fitness of those appointed to the civil service. Fourth, the Governance Commission classifies GOCCs into categories and institutionalizes transparency, accountability, financial viability, and responsiveness in corporate performance by monitoring and evaluating GOCC's performance. While the CSC promulgates policies, standards, and guidelines for the civil service and supervises and disciplines, if needed, all government employees, including those employed in GOCCs with original charters. Fifth, the Governance Commission's mandate is to ensure that government assets and resources are used efficiently, and the government exposure to all forms of liability is unwarranted and incurred through prudent means, while the CSC's mandate is to promote efficiency and professionalism in the civil service. Apart from these differences, the Civil Service Commission remains empowered to take appropriate action on all appointments and other personnel actions, regardless of the enactment of RA 10149. Now let's go to an unbanked decision of your bar chair. This is Manila International Ports Terminal Inc. or MIPT versus Philippine Ports Authority or PPA. This case deals with the issue of the legislative power to revoke franchises. Now for the facts. PPA is a government corporation vested with authority, control, and supervision over the Manila International Port Terminal Complex or the complex at North and South Harbors in Tondo, Manila. While MIPT is a private domestic corporation engaged in port-related services. In 1975, Marcos the Elder, exercising legislative powers, granted MIPT a franchise to operate and manage all facilities, container terminals, warehouses, and other structures to render cargo handling services in the complex at North Harbor for a period of 25 years. To this end, MIPT and PPA executed the MOA, providing for the rules in the operation and management of the complex at North Harbor, as well as detailing the rights and obligations of the parties under the franchise. In 1986, MIPT was sequestered by the Presidential Commission on Good Government or the PCGG. In June 1986, PPA sent MIPT letters informing it of alleged violations of the MOA. In July 1986, in compliance with PPA's directive, PPA submitted a reply denying all the allegations imputed against MIPT. Yet, on the very same day as the submission of the reply, President Cory Aquino, also exercising legislative powers at that time, issued Executive Order Number 30 revoking MIPT's franchise due to alleged substantial violations of the MOA, which allegedly resulted in the deterioration of port services and authorizing PPA to undertake on its own the cargo handling operation at North Harbor. Consequently, PPA sent a letter to MIPT informing it of its plan to take over its business and properties. So, of course, MIPT assailed the revocation of its franchise, alleging that EO 30 is unconstitutional. In this case, the Supreme Court had the occasion to explain the nature of a franchise. It said that in our jurisdiction, a franchise is broadly defined as a special privilege that is not demandable as a matter of right, and when granted, is subject to amendment, alteration, or repeal by Congress. The significance of franchise as a special privilege can be traced to its origin as a royal privilege granted by the king. As a privilege and not a right, the grant of franchise was the prerogative of the monarch. But with the advent of democracy and the change in the form of governments, the understanding of franchise as a privilege has evolved. Specifically, the traditional distinction between franchise as a privilege and franchise as a property right has faded, and as a result also of the recognition that privileges previously granted to individuals should not be taken through the whims of government officials. Such development has also been attributed to the broadening understanding of property as protected by the Due Process Clause. And so, while a franchise is still characterized as a special privilege in the sense that the grant thereof is not a demandable right, and that when granted, it is still subject to the amendment, alteration, or repeal by Congress, we have come to recognize franchise as a property right that cannot be revoked or forfeited without due process of law. Thus, while the legislative power to grant and regulate franchises is broad and plenary, it is subject to the limitations given by the Constitution and the fundamental principle of due process. And even if courts do not ordinarily interfere with the exercise of legislative prerogatives, this is not the case when there is clear, patent, or palpable arbitrary and unreasonable abuse of legislative prerogatives. And in here, the court also discussed due process. It said that the 1935, 1970, 1973, and 1987 constitutions command that no person shall be deprived of life, liberty, or property without due process of law. This provision guarantees protection against any form of arbitrariness on the part of government, whether committed by the legislature, the executive, or the judiciary. Of course, we all know that there are two components of due process. The first, procedural due process, pertains to the procedure that the government must follow before it deprives a person of life, liberty, or property. And the second, substantive due process, refers to the justification for the denial or restriction on life, liberty, or property. The court then said that while due process has no exact definition, the standard in determining whether a person was afforded due process is whether the restriction on the person's life, liberty, or property is consistent with fairness, reason, and justice, and free from caprice and arbitrariness. This standard applies both to procedural and substantive due process. As applied to procedural due process, the question to be asked is whether the person was given sufficient notice and opportunity to be heard. On the other hand, as applied to substantive due process, the question is whether such deprivation or restriction is necessary and fair to the affected parties. Based on this standard, do you think that Mipti was afforded due process? Of course not. The court said that here there is absolutely no doubt that the minimum standards of fair play and freedom from arbitrariness required by due process have been disregarded. The manner in which Mipki's franchise was revoked was so arbitrary and so despotic that it evinces an obvious lack of regard or respect to the fundamental principle of due process and to the constitution that guarantees it. One day it was business as usual for Mipti. The following day, it was informed of its violations. The next day, it no longer has the business. The lack of respect is so flagrant that no person can possibly think that it is justified or at the very least acceptable, even if it was done in the aftermath of martial law. The Supreme Court, speaking through your board chair, was so disappointed that it concluded by saying, "It is ironic that months after toppling a dictator who desecrated the Bill of Rights, bearing the constitutional guarantee of due process, the revolutionary government carried out the same evil. There can be no excuse for it. Revolutionary or not, the government may not arbitrarily deprive a person of life, liberty, or property. This is the guarantee of the constitutional right to due process." Now, from legislative power, let's now go to the executive with this unbucketed case of Nepomuceno versus Duterte on presidential immunity from suit. Here, a writ of mandamus was filed by Pedro Nepomuceno against President Duterte, Health Secretary Francisco Duque, and General Carlito Galvez, who was then the chief implementer of the National Task Force against COVID-19. He wants to compel them to observe the Food and Drug Administration rules on the acquisition, procurement, trials, and use of the Sinovac vaccine, and for them to properly observe the procurement law. He also prays for the DOH FDA to issue a cease and desist order for the purchase and use of the Sinovac vaccine and for it and all other COVID-19 vaccines to undergo the required trials in the Philippines before they are given the go signal for emergency and or regular use. So at the core of the petition is the concern raised by Nepomuceno on the efficacy of the Sinovac vaccine and the absence of a complete study on how it really fares in addressing the COVID-19 disease. But before delving into the contents of the petition, the court immediately said that President Duterte must be dropped as a respondent. Settled is the rule that the President of the Republic of the Philippines cannot be sued during his tenure. This immunity from suit applies to the President, regardless of the nature of the suit filed against him, for as long as he sits as the President of the Republic of the Philippines. The court then cited the case of De Lima versus President Duterte, where then Senator De Lima sued President Duterte in a petition for a writ of habeas data, seeking to enjoin the latter from committing acts allegedly violative of her right to life, liberty, and security. In her petition then, Senator De Lima argued that President Duterte is not entitled to immunity from suit, especially from a petition for the issuance of the writ of habeas data because his actions and statements were unlawful or made outside of his official conduct. The Office of the Solicitor General countered that the immunity of the sitting president is absolute and that it extends to all suits regardless of the petition, and it includes petitions for the writ of amparo, the writ of habeas data, etc., etc. And that this present suit is actually the exact distraction that the immunity seeks to prevent, because it will surely distract the president from discharging his duties as chief executive. In resolving the petition, the court pronounced that presidential immunity applies regardless of the nature of the suit brought against an incumbent president. Then, with regard to the submission that the president must first invoke the privilege of immunity before the same may be applied by the courts, the Supreme Court said that if the court were to first require the president to respond to each and every complaint brought against him, and then to avail himself of presidential immunity on a case-to-case basis, then the rationale for the privilege, that is, protecting the president from harassment, hindrance, or distraction in the discharge of his duties would very well be defeated. It takes little imagination to foresee the possibility of the president being deluged with lawsuits, baseless or otherwise, should the president still need to invoke his immunity personally before a court may dismiss the case against him. And so the court again reminds litigants that an incumbent president of the Republic of the Philippines cannot be sued in any proceeding. With executive powers wholly vested in the President of the Philippines, he should be freed from any distraction that would imperil the performance of his duties as mandated by the Constitution. Thus, presidential immunity shields President Duterte from facing any complaint or petition during his tenure. While he remains accountable to the people, the only proceeding for which he may be involved in litigation during his term of office is an impeachment proceeding, which is obviously not the case at bar. Now, let's discuss the ordinance making power of the president through the Anbang case of the province of Pampanga versus executive secretary. So in 1992, about a year after Mount Pinatubo erupted, the Sangguniang Panlalawigan of Pampanga enacted several tax ordinances providing for tax on the fair market value of quarry resources extracted from public lands and imposed permit fees for quarry operations. In 2003, President Gloria Macapagal Arroyo issued Executive Order Number 224, rationalizing the extraction and disposition of sand, gravel, and lahar deposits in the provinces of Pampanga, Tarlac, and Zambales. It created a task force that will ensure compliance by all permit holders with the terms and conditions of their permits, properly monitor the volume of extracted materials, and collect the proper taxes and fees from sand and gravel and lahar operations. This did not sit well with the province of Pampanga, who immediately filed before the RTC a petition for declaratory relief seeking to declare EO 224 as unconstitutional. The trial court ruled in favor of the province and struck down EO 224 for being a form of executive legislation without a valid delegation of legislative authority. Now, in order to resolve this case, it is important for us to know what executive orders are. So, first, executive orders pertain to the President's acts that provide rules to implement or execute existing laws, and jurisprudence provides that an administrative issuance, such as an executive order, must comply with the following requisites to be valid. First, its promulgation must be authorized by the legislature. Second, it must be promulgated in accordance with the prescribed procedure. Third, it must be within the scope of the authority given by the legislature. And fourth, it must be reasonable. However, a distinction must be made between the President's inherent ordinance-making powers and delegated legislative power. Apart from whatever rulemaking power that Congress may delegate to the President has inherent ordinance powers covering the executive branch as part of the power of executive control. Recall Section 17, Article 7, that the President shall have control of all executive departments, bureaus, and offices. By its nature, this ordinance power does not require or entail any delegation from Congress. In differentiating the delegated legislative power from the ordinance-making power, you must remember that under the delegated legislative authority, the power to issue implementing rules creates rights and obligations that affect the public at large, while the ordinance-making power of the President is merely the authority to issue intra-branch orders and instructions or internal rules for the executive branch, which do not bind the public. This is why implementing rules and regulations are subject to the rule of publication for their effectivity, while internal rules or instructions in the executive department are not. Here, the court held that EO 224 is a valid exercise of the President's ordinance-making power. Nothing in EO 224 suggests that the task force exercises control over the provincial government. It also does not authorize the task force to impose its own set of rules or regulations over the local government unit when it comes to the collection of quarry taxes, fees, and charges. It is merely a supervisory mechanism, as seen in how it directs the task force to oversee the collection and ensure that the appropriate shares are remitted to the local government units concerned. Again, the task force would merely oversee the collection of all necessary taxes and fees that may be derived from the extraction of industrial sand and gravel in the territorial jurisdiction of the concerned local government unit. The task force oversight function is in line with the President's power of general supervision over local governments to ensure that local programs are aligned with national goals. And the President's power of general supervision means the power of a superior officer to see to it that subordinates perform their functions according to law. This is distinguished from the President's power of control, which is the power to alter or modify or set aside what a subordinate officer had done in the performance of his duties and to substitute the judgment of the President over that of the subordinate officer. The power of control gives the President the power to revise or reverse the acts or decisions of a subordinate officer involving the exercise of discretion. Here, the President, through EO 224, is merely exercising general supervision and not control over the province of Pampanga. Hence, PO 224 is constitutional. Now we go to the constitutional commissions with recent cases involving the Commission on Audit. First, we have the en banc case of Figueroa versus COA, involving tickets to the movie Ballet starring Anne Curtis. I, for one, have not seen the movie, but since it won Best Picture in the Metro Manila Film Festival, then I presume that it must be really good to warrant this kind of controversy. So what happened in this case was Pagcor purchased 89,000 ticket passes for the movie Baler in the amount of 26,700,000 pesos, allegedly for the benefit of Batang Iwas Droga Foundation Inc. or BIDA Foundation Party List, whose first nominee is the daughter of the chairman and CEO of Pagcor at that time. Pagcor's plan was to distribute the movie passes to 12 Pagcor casino branches, which shall in turn be chargeable against the patrons' respective player tracking system points. Thereafter, Pagcor issued a check to be the foundation in the amount of 26,700,000 pesos. However, following the conduct of a post-audit examination, COA found irregularities such as only the amount of somewhere around 2 million was charged against the patrons' player tracking system points, and that the balance of around 24 million was charged to other accounts without the approval of the board of directors. And then there was also the issue of the payment of the 26 million despite the absence of supporting documents. So a notice of disallowance was issued. This was contested by the responsible Pagcor officers and board of directors. However, on review, the COA decision sustained the propriety of the issuance of the notice of disallowance and fixing the liability therein of Pagcor's responsible officers. It further ruled that Pagcor's purchase of movie tickets is ultra vires. And so, the responsible officers of Pagcor filed a petition for certiorari under Rule 64 before the Supreme Court, alleging that COA committed grave abuse of discretion in issuing the notice of disallowance. What do you think was the ruling of the Supreme Court? It said that, yes, COA committed grave abuse of discretion. The court rationated that COA's audit jurisdiction over Pagcor is neither absolute nor all-encompassing because Pagcor is a sui generis GOCC. It explained that Pagcor is tasked with a dual role to operate and to regulate gambling casinos and clubs as a means to promote tourism and generate sources of revenue for the government. Presenting from this dual governmental and proprietary functions, Pagcor is sui generis. On the one hand, it exercises a sovereign function by regulating gambling, casinos, and clubs. On the other hand, it generates income for the government by operating said gambling establishments. Consistent with Pagcor's unique corporate and fiscal features, the Pagcor Charter provides a mechanism that effectively segregates Pagcor's earnings owed to the government from the rest of its corporate revenue or funds. In this regard, the Pagcor Charter limits the COA's audit jurisdiction over Pagcor's fund to the 5% franchise tax and the government's 50% share of the gross earnings. Then the rest of Pagcor's money are corporate fund or revenue not subject to government audit. The court then found that the subject amount of 26,700,000 pesos neither comes from the 5% franchise tax or Pagcor's 50% gross earnings. This amount was actually sourced from PAGCOR's operating expenses fund, particularly the corporation's marketing expenses. So, lusot na lusot siya. The court also declared that COA does not have the power to declare as ultra vires the acts of PAGCOR's board of directors. It enumerated the principal duties of the COA as follows. First, examine, audit, and settle all accounts pertaining to the revenue and receipts of and expenditures or uses of funds and property owned or held in trust by or pertaining to the government. 2, promulgate accounting and auditing rules and regulations, including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant, or unconscionable expenditures or uses of government funds and properties. 3, submit annual reports to the President and the Congress on the financial condition and operation of the government. 4, recommend measures to improve the efficiency and effectiveness of government operations. 5, keep the general accounts of government and preserve the vouchers and supporting papers pertaining thereto. 6, decide any case brought before it within 60 days. And 7, perform such other duties and functions as may be provided by law. The Supreme Court here said that neither the 1987 Constitution nor PD 1445, also known as the Auditing Code of the Philippines, or any other related statute grants COA the power to strike down as void or declare ultra vires the acts of the Board of Directors of PAGCOR or any other GOCC. Doing so is grave abuse of discretion amounting to lack or excess of jurisdiction. Very interesting, right? So next we have another recent Anbang COA case docketed as Taisei Shimizu Joint Venture versus COA and the Department of Transportation or DOTR about the nature of money claims brought before the COA. Here, Taisei Shimizu won the contract award for the construction of the new Iloilo Airport. As project proponent, DOTR entered into a contract agreement with Taisei following the project's completion and delivery. It turned out that some of Taisei's billings had been left unpaid. After its initial effort to collect failed, Taisei filed with the Construction Industry Arbitration Commission or SIAC a request for arbitration and complaint, seeking payment of certain money claims. In defense of the government, the DOTR responded to the complaint and actively participated in the SIAC proceedings. Under the SIAC's final award, it granted 8 of Taisei Shimizu's claims amounting to roughly 200 million. In order to execute the award, DOTR advised Taisei in writing that the arbitral award should be referred to the COA as condition sine qua non for payment. Thus, Taisei filed with the COA a petition for enforcement and payment of the arbitral award. By decision, the COA approved payment, but only to the extent of around 100 million or less than half of the total SIAC award. Asserting its primary jurisdiction over money claims against government agencies and instrumentalities, the COA reviewed the evidence and on the basis of which it found that only one claim was allegedly in accordance with law and the rules. Taisei moved for reconsideration but was denied. Thus, it filed a petition with the Supreme Court charging COA with grave abuse of discretion amounting to lack or excess of jurisdiction in disturbing the immutable and final award in Taisei's favor. On the other hand, COA countered that A, it has primary jurisdiction over all money claims against the government. B, even if a final and executory judgment had already been validated, a monetary claim against government agency, its approval is still a condition sine qua non for payment. And in approving or disproving the claim, the COA exercises a quasi-judicial function requiring it to rule on the propriety of the money claim based on the evidence presented before it, and D, that it could not be charged with grave abuse of discretion when its action was simply in accord with the law and the evidence. The Supreme Court in this case, however, sided with Taisei, and in doing so explained that there are two main types of money claims which the COA may be confronted with. First are money claims pursued as an original action for collection of payment. This arises, for example, where a contractor has not been paid by a government agency and seeks collection of the amount due. By law, on the general principle that the state cannot be sued without its consent, the claim must first be filed with the Commission on Audit. As a rule, COA's jurisdiction is limited to liquidated money claims. Then, there are also those money claims that arise from a final and executory judgment of a court or arbitral body, such as the SIAC. This is the second type of money claim. These claims may result from a judicial decision on an unliquidated money claim or the decision of an arbitral body where the contract contains an arbitration clause or the parties consented to arbitration, or even cases which should have been first filed with the Commission under the doctrine of primary administrative jurisdiction, but were filed with the courts without objection from any of the parties. COA's jurisdiction over original actions for money claims refers to the quasi-judicial aspect of government audit, which includes the investigation, weighing of evidence, and resolving whether items should or should not be included, or as applied to a claim, whether it should be allowed or disallowed in whole or in part. As for the second type of money claim, the COA may not set aside the final and executory decision of another tribunal, even in the exercise of its broad power of audit. While the COA's constitutional mandate to act as a dynamic, effective, efficient, and independent watchdog of the government, COA's primary and exclusive constitutional authority to examine, audit, and settle claims against government funds must yield to the principle of immutability of final judgment. So on this score, the Supreme Court laid down a conceptual framework for the guidance of the COA, the bench, the bar, and the public pertaining to the COA's audit power vis-a-vis the second type of money claims which may be brought before it during the execution stage. It said that COA's audit review power over money claims already confirmed by final judgment of a court or other adjudicative body is necessarily limited. Thus, once a court or other adjudicative body validly acquires jurisdiction over a money claim against the government, it exercises and retains jurisdiction over the subject matter to the exclusion of all others, including the COA. B, the COA has no appellate review power over the decisions of any other court or tribunal. C, the COA is devoid of power to disregard the principle of immutability of final judgments. And finally, that the COA's exercise of discretion in approving or disapproving money claims that have been determined by final judgment is akin to the power of an execution court. I suggest that you also memorize this enumeration. So, in sum, the COA here gravely abused its discretion when it modified or amended the SIAC's final and executory judgment. I think let's pause here for a while so that you guys may have a short mental health break. So I'll see you after the short break. And we're back. Let's now proceed to citizenship through this case of Republic versus Lao. The main issue in this case is whether a trial court in a petition for correction of entry in a birth certificate under Rule 108 of the Rules of Court can change the nationality of the parents of the person in the birth certificate. The Supreme Court ruled in the affirmative. It said that yes, the trial court can do that. It said that the birth certificate, more than a historical record of one's birth, is a vital marker of identity. Therefore, acts and events, though occurring after birth, may be annotated on the birth certificate so long as they are consistent with the legal truth and a special law provides for its effects. So this case actually involves two consolidated petitions for review on certiorari directly filed before the Supreme Court by the Republic of the Philippines, represented by the Special Committee on Naturalization, or the SCN, raising pure questions of law. In the first case, the Republic questions the decision of RTC Manila that allowed the change in the nationality of the parents of Winston Bryan and Christopher Troy as entered in the respective certificates of live birth. In the second case, the Republic questions the decision of RTC Quezon City that allowed the same change in the nationality of the parents of John Nicolas as entered also in the certificate of live birth. Actually, all these three are siblings. For the antecedent facts, on October 14, 1962, Lau Qian Ben and Xia Kong Leong married at the Our Lady of Lourdes, Santa Teresita Parish, Quezon City. They are the parents of John Nicolas, Winston Bryan, and Christopher Troy. In the respective certificates of live birth of John Nicolas, Winston Bryan, and Christopher Troy, issued by the now defunct National Statistics Office, the indicated nationality of both their parents were Chinese. Thereafter, Lau Qian Ben applied for naturalization as a Filipino citizen before the Special Committee on Naturalization, pursuant to Letter of Instructions number 270. The application was granted and Lau Qian Ben was conferred with Philippine citizenship under Presidential Decree number 923. He took his oath of allegiance to the Republic of the Philippines on June 15, 1976, and was issued his certificate of naturalization on the same day. Xia Kong Leong, being the wife of Lau Qian Ben, was likewise conferred with Philippine citizenship pursuant to PD number 923. She was issued a certificate of naturalization and on the same day took the oath of allegiance to the Republic of the Philippines. Meanwhile, their kids, John Nicolas, Winston Bryan, and Christopher Troy, all born and raised in the Philippines, studied in Philippine schools from elementary to college. They all thereafter married Filipino citizens and raised their kids here also in the Philippines. And so the three siblings filed their respective petitions for correction of entry in their respective certificates of live birth before the regional trial court. They contended that the nationality of their parents should be changed from Chinese to Filipino, considering that they had already been naturalized as Filipino citizens pursuant to Philippine laws. As mentioned, these were granted by the trial court. However, the Republic contests these. It maintained that there was no error to correct in the sibling certificate of live birth. Citizenship, according to the Republic, is determined at the time of one's birth. On the day respondents Winston Bryan, Christopher Troy, and John Nicolas were born, their parents were still Chinese nationals. Since the siblings were born to natural-born Chinese citizens, the siblings are necessarily naturally born Chinese, and the nationality of their parents was correctly entered as Chinese in the respective certificates of live birth. The Republic further contended that even assuming that the nationality of the siblings' parents as entered into their certificates of live birth may be changed and therefore extending Filipino citizenship to the siblings, The change in the entry can only be done after an appropriate proceeding under the implementing rules and regulations of Presidential Decree number 836 in relation to PB number 923. This proceeding should be conducted before the Special Committee on Naturalization to determine if indeed the siblings are qualified to become naturalized Filipinos. But the Supreme Court ruled against the Republic. It held that an event occurring after birth, such as the naturalization of parents, may be recorded in the civil register via recourse to a judicial proceeding under Rule 108 of the Rules of Court. As to the Republic's second contention that before the entry in the birth certificate can be changed, Winston Bryan, Christopher Choi, and John Nicholas should first show that they had undergone the appropriate proceeding under the implementing rules and regulations of PD number 836 in relation to PD 923 before the Special Committee on Naturalization. The court held that this is not anymore necessary because Supreme Court explained that naturalization may either be administrative, judicial, or legislative. As the name implies, administrative naturalization is the grant of Filipino citizenship to aliens via administrative proceedings and is currently governed by RA number 9139. Judicial naturalization grants Filipino citizenship through a judicial decree and is governed by Commonwealth Act number 423 or the revised naturalization law. Lastly, legislative naturalization bestows Filipino citizenship through a statute enacted by Congress. Here, it is undisputed that Winston Bryan, Christopher Choi, and John Nicholas's father, Lau Kian Ben, applied for naturalization under Letters of Instruction number 270, and his application was granted. And because of this, this naturalization extended to the alien wife and minor children of the person naturalized upon the wife's showing that she does not suffer from any of the disqualifications under Letter of Instructions number 270 and that she and her minor children reside permanently in the Philippines at the time of her husband's naturalization. In other words, the only persons to undergo the proceeding before the Special Committee on Naturalization will only be the person naturalized and his wife. The minor children, in the words of Presidential Decree number 836, follow the acquired Filipino citizenship of their mother. Thus, this is a clear case of derivative naturalization of minor children that flowed from the naturalization of their parents. Now we go to the Bill of Rights with another case from your bar chair entitled Diaz versus People on the issue of validity of search warrant. So here, upon application of a police officer, a judge issued a search warrant which states, it appearing to the satisfaction of the undersigned that after examining under oath by searching questions and answers to Pio Avila, there exists a probable cause for violation of RA 9165 which has been committed, and there is a good and sufficient reason to believe that Merly Diaz, alias Merly Palayok, has possession and control of undetermined amount of methamphetamine hydrochloride, commonly known as shabu, which she is keeping and concealing in her house at Gitna, Barangay Cuyab, San Pedro, Laguna. You are therefore hereby commanded to make an immediate search at any time of the day or any time of the night, the house aforestated, and thereafter seize and bring said undetermined amount of prohibited drugs to the undersigned so that the same could be dealt with in accordance with law. In support of PO2 Avila's application, an informant, a certain Labrador, submitted to the judge two sketches of the house of Merly in Gitna, Barangay Cuyab, San Pedro, Laguna. The first sketch of Labrador depicted a floor plan of a studio-type apartment with an anteroom where the entrance gate of the property was located. The second sketch depicted three buildings along Gitna, one of which was marked with a large X enclosed in a square that supposedly identified Merle's house. And so, pursuant to the search warrant, members of the San Pedro Police Station searched the house of Merle. Approximately 9 grams of shabu were then found and seized from the premises. Merle was immediately arrested and detained by the members of the searching team for her alleged violation of Section 11 of RA 9165. Immediately after the search and Merle's arrest, the following information was uncovered from Merle. First, that the complete address of her residence is number 972 Gitna, Barangay Cuyab, San Pedro, Laguna. Second, that the house located at number 972 Gitna, Barangay Cuyab, San Pedro, Laguna was divided into 5 separate units, each occupied by Merle and her 4 siblings and their respective families. So now, Merle wants to quash the search warrant on the ground that it was in the nature of a general warrant which failed to describe with particularity the place to be searched. She said that the warrant failed to distinguish her unit, which was the place intended to be searched, from the other units or rooms representing the 4 other households inside the house located in Gitna, Barangay Cuyab, San Pedro, Laguna. In denying Merle's petition, the Supreme Court first enumerated the requisites of a valid search warrant as laid down in Article 3, Section 2 of the 1987 Constitution and in Rule 126, Section 4 of the Rules of Court, which are that first, probable cause is present. Second, such probable cause must be determined personally by the judge. Third, the judge must examine in writing and under oath or affirmation the complainant and the witnesses he or she may produce. Fourth, the applicant and the witnesses testify on the facts personally known to them. And 5, the warrant specifically describes the place to be searched and the things to be seized. The absence of any of these requisites will cause the downright nullification of the search warrant. Now, this case involved the 5th requisite of specificity of the place to be searched. The court explained that a search warrant issued must particularly describe the place to be searched and the persons or things to be seized in order for it to be valid. Otherwise, it is considered as a general warrant which is prescribed by both jurisprudence and the Constitution. The particularity of the place described is essential in the issuance of search warrants to avoid the exercise by the enforcing officers of discretion to decide on their own where to search and whom and what to seize. Additionally, the requisites of particularity is related to the probable cause requirement in that, at least under some circumstances, the lack of a more specific description will make it apparent that there has not been a sufficient showing to the court that the described items are to be found in that particular place. Notably, it is well entrenched in our jurisprudence that a description of the place to be searched is already sufficient if the officer with the warrant can ascertain and identify with reasonable effort the place intended and distinguish it from other places in the community. Hence, a designation that points out the place to be searched to the exclusion of all others and on inquiry unerringly leads to the peace officers to it satisfies the constitutional requirement of definiteness. Simply put, the test of whether the requirement of definiteness or particularity has been met is whether the description of the place to be searched under the warrant is sufficient and descriptive enough to prevent a search of other premises located within the surrounding area or community. A place may refer to a single building or structure or a house or residence, such as in the case at Bar. Murphy argued that the coverage of the warrant was broader than appropriate, considering that the search covered the whole house and was not limited to her unit actually occupied by her. To her mind, this gave the police officers undue discretion in enforcing the warrant, which they allegedly did when they searched the units occupied by Murley's siblings. However, the Supreme Court held that the omission of the warrant to indicate that the place to be searched contained 5 rooms, which were separately occupied by Murley and her siblings, and confined the search to Murley's unit is inconsequential and therefore does not affect the warrant's validity for the following reasons. First, the unit or rooms where Murley and her siblings live all form an integral part of the house. The rooms inside the house, which were in fact occupied by family members of Murley, cannot be treated separately as they form part of the house where Murley actually resided. Second, even assuming that an ambiguity or inaccuracy in the interior description of the place to be searched may affect the validity of the warrant, such finding, which only emerged after the warrant was issued, has no bearing on its validity or invalidity. That the house of Murley was composed of several units separately occupied by her siblings was discovered only after the search warrant was enforced and the search of Murley's house was conducted by the police officers. The police could not have known or detected the multi-unit character of Murley's house prior to the actual search. In this regard, the court held that the validity of the warrant must be assessed on the basis of the pieces of information made available to the judge at the time that the police officer applied for the issuance of the search warrant, which in this case were sufficiently supported by the sketches of Labrador and the testimonies of PO2 Avila, who were in fact personally examined by the judge in the form of searching questions and answers. Now, let's proceed to another case by your bar chair. This is the case of Uy versus People on the validity of warrantless search incidental to a lawful arrest. Here, members of the PNP set up a mobile checkpoint pursuant to the implementation of the COMELEC gun ban. Uy, who was then driving a red motorcycle, passed by the mobile checkpoint. The motorcycle was then flagged down and the police asked Uy for his ORCR. However, he failed to produce the documents. The police authorities then became suspicious that the motorcycle might have been stolen, considering Uy's failure to produce the ORCR. Moreover, upon inspection of the motor vehicle, the police officers chanced upon a plastic cellophane protruding from the tools compartment. When Uy opened the tools compartment, the police officers found a small bundle of dried marijuana placed inside a transparent cellophane. The police officers then scrutinized the motorcycle and further found the same transparent cellophane in the driver's seat. Upon opening the driver's seat, the police officers discovered 5 more bundles of marijuana wrapped in a cellophane. And so immediately after, the police officers brought Uy to the police station where he was further interviewed and eventually detained. The marijuana specimen were brought to the laboratory for examination. And based on the foregoing, while it is true that the root of the encounter of the police officers and Uy was due to the mobile checkpoint in the implementation of the COMELEC gun ban, the arrest was not made by reason of the Comelec gun ban or any traffic violation. Instead, it was in light of Ui's failure to present his ORCR, which raised suspicions on the part of the police officers, prompting them to inquire further and look into the motor vehicle on the theory that petitioner or Uy might be committing a crime, or the motor vehicle itself is the subject of the crime already committed. The consequent search conducted by the police officers led to the confiscation of marijuana. Now, the question is, was the warrantless search valid? What do you think? In arriving at the answer, the court first explained the concept of searches and seizures. So, Section 2, Article 3 of the 1987 Constitution mandates that search and seizures must be carried out through or on the strength of a judicial warrant predicated upon the existence of probable cause. Otherwise, searches and seizures done without a valid warrant are considered intrusive and unreasonable within the meaning of the said constitutional provision. The Constitution further provides safeguards such that any evidence obtained and confiscated on the occasion of unreasonable searches and seizures are considered tainted and consequently inadmissible in evidence for any purpose in any proceeding. However, there is a recognized exception to the need of securing a warrant before a search may be effected. And that is a warrantless search incidental to a lawful arrest. In such instances, the law requires that there must be a lawful arrest first before a search can be made. The process cannot be reversed. Moreover, Section 5, Rule 113 of the Rules of Court provides for instances when a lawful arrest may be effected without a warrant. These are A. Arrest of a suspect in flagrante delicto. B. Arrest of a suspect where, based on personal knowledge of the arresting officer, there is probable cause that said suspect was the perpetrator of a crime which has just been committed. And C. An arrest of a prisoner who has escaped from custody, serving final judgment, or temporarily confined during the pendency of his case, or has escaped while being transferred from one confinement to another. Among the circumstances where a warrantless arrest is allowed, the arrest of a suspect in flagrante delicto imposes a rigid, if not strict, compliance with its elements. An in flagrante delicto arrest requires the concurrence of two elements. First, the person arrested must execute an overt act indicating that he or she has just committed, is actually committing, or is attempting to commit a crime. And B, the overt act was done in the presence or within the view of the arresting officer. Jurisprudence has also carved out an additional exception to the necessity of securing a search warrant prior to the conduct of a search. This includes the search of a moving vehicle. This case presents us with a situation wherein an individual was arrested during a checkpoint search. Setups of the military or police checkpoints are considered a variant of searching moving vehicles, which are not illegal per se for as long as its necessity is justified by the exigencies of public order and conducted in a way least intrusive to the motorist. Inspections at checkpoints are not violative of an individual's right against unreasonable searches if limited to the following. First, the officer merely draws aside the curtain of a vacant vehicle which is parked on the public fairgrounds. B, simply looks into a vehicle. C, flashes a light therein without opening the car's doors. D, where the occupants are not subjected to a physical or body search. E, where the inspection of the vehicle is limited to a visual search or visual inspection. And E, where the routine check is conducted in a fixed area. The Supreme Court has ruled in several instances that although, as a general rule, motorists as well as pedestrians passing through checkpoints may only be subjected to a routine inspection, vehicles may also be stopped to allow authorized personnel to conduct an extensive search when there is probable cause which justifies a reasonable belief on the part of the law officers that either a motorist is a law offender or that the contents of the vehicles are or have been instruments of some offense. Here, the police officers had probable cause to believe that Uy is a law offender because his failure to present the ORCR of his motorcycle raised the suspicion that the motorcycle must be stolen. This is because in the normal course of things, vehicle owners would usually have their ORCR in their vehicles ready to be presented when authorities ask for them. This therefore justified the extensive search made by the police officers. Unfortunately, the police officers in this case did not comply with the rule on chain of custody. The chain of custody refers to the duly recorded, authorized movements and custody of the seized drugs at every stage, from the moment of confiscation to the receipt in the forensic laboratory for examination until it is presented to the court. Section 21 of RA 9165, or the Comprehensive Dangerous Act, requires the apprehending officers to immediately conduct the marking, physical inventory, and photograph of the seized drugs. Moreover, the physical inventory and taking of photographs shall be conducted in the presence of A, the accused or the persons from whom such items were confiscated and or seized, or his or her representatives or counsel. B, a representative from the media. C, a representative from the Department of Justice. And D, an elected public official after seizure and confiscation. This procedure laid out in Section 21 is considered substantive law and not merely a procedural technicality. The law requires that the police authorities implementing RA 9165 strictly comply with the chain of custody procedures. Although failure to strictly do so does not ipso facto render the seizure and custody over the illegal drugs as void and invalid if there is a substantial ground for such non-compliance and if the integrity and evidentiary value of the seized evidence were preserved. However, in this case, there was total lack of compliance. A review of the pieces of evidence submitted by the parties show that an inventory report was not accomplished by any of the police officers. Absent the inventory report, the required presence of the insulating witnesses cannot be considered to have been complied with. Consequently, rendering a judgment of conviction without being able to establish that Uy, along with the required witnesses under Section 21 of RA 9165, were able to personally see the movement of the seized drugs amounts to a violation of substantive law. So, of course, Uy was acquitted in this case. All right, let's now move on to another case by your bar chair. This is Morada versus Rias. This case deals with the requirements for the issuance of a writ of amparo in instances of alleged enforced disappearances. For the facts, on October 14, 2015, at around 8 a.m., Marilyn received a text message from her daughter that Marilyn's son, Johnson, was arrested and detained by the barangay tanods of Caloocan City for alleged theft of a mobile phone in the house of another barangay tanod, Randy Rias. Marilyn then went to the barangay hall at around 7 p.m. of the same date. And at the barangay hall, Marilyn said that The barangay desk officer Rolly informed her that Johnson was already released from the custody of the barangay as evidenced by the entry in the barangay blotter signed by Johnson himself. In December 2015, Marilyn went to the Northern Police District to report that her son was missing. Marilyn said that an investigation was conducted, but the same was terminated in view of the lack of a witness to shed light on Johnson's disappearance and the insistence of the barangay officers that Johnson was already released from their custody. In the meantime, rumors circulated within the barangay that Johnson had already been extrajudicially killed and that his body was mixed in cement in order to conceal the incident. This prompted Marilyn to institute a petition for the issuance of a writ of amparo for the alleged enforced disappearance of Johnson. The RTC denied the petition, saying that there was no showing of any refusal on the part of the named barangay officers and police to acknowledge or to give information on Johnson's whereabouts, such that there was no intention to remove Johnson from the protection of the law for a prolonged period of time. Marilyn appealed, arguing that the lack of cooperation on the part of the authorities amounted to a refusal on their part to acknowledge or give information on the fate or whereabouts of Johnson, showing their intention to remove him from the protection of the law. The Supreme Court denied Marilyn's petition for the issuance of a writ of amparo and said that no substantial evidence exists to prove Marilyn's claim. The court then outlined the elements constituting enforced disappearance as defined under RA 9851 or the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity. These are the elements constituting enforced disappearance. A, that there was an arrest, detention, abduction, or any form of deprivation of liberty. B, that it was carried out by or with the authorization, support, or acquiescence of the state or a political organization. C, that it be followed by the state or political organization's refusal to acknowledge or give information on the fate or whereabouts of the person subject of the amparo petition. And D, that the intention for such refusal is to remove subject person from the protection of the law for a prolonged period of time. There is no question that the first and second elements are attendant in this case. However, the third and fourth elements are sorely lacking. While it is admitted that Johnson was arrested for the alleged theft that he committed, it was also sufficiently established that he was already released from custody as evidenced by the barangay blotter signed by Johnson himself. And as opposed to the unsubstantiated allegations of Marilyn that it was the barangay tanods who are responsible for Johnson's disappearance, the Supreme Court accorded greater weight to the documentary evidence presented by the tanods exhibiting that Johnson was no longer in their custody when he disappeared. This documentary proof of Johnson's release from detention is, to the mind of the court, substantial evidence to establish that the tanods have not refused to acknowledge or give information on the whereabouts of Johnson, as in fact, it should be regarded as information positively showing that Johnson was no longer under the hold of the barangay officials. Accordingly, there was no intention to remove Johnson from the protection of the law for a prolonged period of time, as he had been released already. And so the court was unable to see any alleged enforced or involuntary disappearance that would warrant the issuance of the writ of amparo. It then said that for the issuance of the writ, It is not sufficient that the person's life is endangered. It is not even sufficient to allege and prove that a person has disappeared. It has to be shown by the required quantum of proof that the disappearance was carried out by or with the authorization, support, or acquiescence of the government or a political organization, and that there is a refusal to acknowledge the same or to give information on the fate or whereabouts of the missing persons. So the case was dismissed. Let's now move on to public officers. Here we have the case of DTI versus Enriquez, tackling the issue on the disciplinary authority of department secretaries over presidential appointees within their department. So what happened in this case was prompted by a news article about corrupt practices in the issuance of importation clearances by an unnamed high-ranking officer of the Department of Trade and Industry. Then DTI Secretary Cristobal instructed his Undersecretary Dimagiba, to conduct an investigation. USEC Dimagiba then reported his initial findings to Secretary Cristobal, finding unauthorized issuances of Respondent Enriquez, who was then the Fair Trade and Enforcement Bureau Director with regard to certain importations. Pursuant to these findings, USEC Dimagiba opined that there is sufficient basis to file administrative and/or criminal complaints against Enriquez, recommending that a full-blown investigation on all activities in Enriquez's office be conducted and that the latter be preventively suspended pending investigation. And so, Secretary Cristobal issued a department order creating a special investigation committee mandated to conduct a full investigation on Enriquez. The department order also closed the committee with the authority to issue a preventive suspension order, among others. Enriquez objected to the committee's disciplinary authority over him. He claimed that Secretary Cristobal lacked disciplinary jurisdiction over him as he is a presidential appointee occupying a high-ranking position with salary grade 28. Enriquez averred that it is actually the Presidential Anti-Graft Commission which has the authority and jurisdiction to investigate, hear, and decide administrative cases against a presidential appointee occupying a director position with salary grade 28. The Supreme Court, however, ruled in favor of the DTI secretary. It affirmed that a department secretary has authority to investigate as well as to designate a committee or an officer to investigate a bureau director who is a presidential appointee, such as Enriquez. The Supreme Court pointed to the Administrative Code, which states that one of the powers and functions of a department secretary is to exercise disciplinary powers over officers and employees under the secretary in accordance with law, including their investigation and the designation of a committee or officer to conduct such investigation. However, when it comes to a presidential appointee, a department secretary can only investigate but not impose a penalty on the erring presidential appointee. For presidential appointees, the power to impose penalty resides with the president pursuant to his power of control under the Constitution and the Administrative Code. Likewise, the ombudsman was given such power to impose penalties. And while the power to impose penalty remains with the president or to the ombudsman, the power to investigate as well as to designate a committee or officer to investigate and thereafter to report its findings and to make recommendations may be delegated to and exercised by subordinates or a special commissions or committee specifically created for such purpose. Stated more specifically, while it is the president as the chief executive or the ombudsman as mandated by law who has the authority to impose penalty upon erring presidential appointees, it does not preclude said disciplining authorities from utilizing, as a matter of practical administrative procedure, the aid of subordinates to investigate and report to them the facts on the basis of which the president or the ombudsman, as the case may be, may make their decision. It is sufficient that the judgment and discretion finally exercised are those of the officer authorized by law. As I've mentioned earlier, the Administrative Code expressly provides for the department secretary's power to investigate and to designate a committee or officer for such purpose. So remember that the disciplinary jurisdiction of a department secretary over presidential appointees is limited to the power to investigate, which does not include the power to impose penalty. So what should happen is that the department secretary must forward the investigation report with his recommendation to the president, and it is up to the president to adopt the recommendation and impose a penalty on his appointee. Is that clear? Cool. Now, let's look into the liability of government employees for notices of disallowances through the Anbang case of Bilibili versus COA. Here in 2012, the National Commission on Indigenous Peoples, or the NCIP Board of Trustees, via a board resolution, authorized the NCIP to forge a memorandum of agreement with the Ateneo de Naga University for admission in ADMU's Masters in Public Management Scholarship Program for 24 NCIP officials and employees whose tuition fees and miscellaneous expenses shall be paid by the NCIP in the amount of somewhere around 3 million. This 3 million was taken from a realignment from the agency's unutilized 2011 budget. So on post-audit, this was of course flagged by COA. NCIP explained to the COA audit team that per its proposed budget for fiscal year 2012, it is included as item therein called Human Resource Development for its officers and employees. But the Department of Management, or DBM, did not approve it because it was outside the NCIP's priority project. But the NCIP nonetheless went on with the project by realigning its unutilized fund for general administration and support services to augment the training and scholarship program for fiscal year 2012. The COA then issued a notice of disallowance. Could you guess why? Because it violates the constitutional prescription on augmentation of funds not included in the GAA or the General Appropriations Act. Remember that Section 25(5), Article 6 of the 1987 Constitution provides that no law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may, by law, be authorized to augment any item in the General Appropriations Law for their respective offices from savings and other items of their respective appropriations. And so, for there to be a valid transfer of appropriated funds, the following requirements must concur. First, There must be a law authorizing the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of the Constitutional Commission to transfer funds within their respective offices. Second, the funds to be transferred are savings generated from the appropriations for their respective offices. And third, the purpose of the transfer is to augment an item in the general appropriations law for their respective offices. Obviously, the NCIP has no legal basis for its realignment. So the question now is, are the recipients of the scholarships liable to return the amount of the scholarship? It depends on the rules on return laid down by the court in the case of Madera versus COA. Again, it would be most helpful for you to memorize the rules on return. So it says here, number 1, if a notice of disallowance is set aside by the court, no return shall be required from any of the persons held liable therein. Number 2, if a notice of disallowance is upheld, the rules on return are as follows. A. Approving and certifying officers who acted in good faith in regular performance of official functions and with the diligence of a good father of the family are not civilly liable to return, consistent with the administrative code. B. Approving and certifying officers who are clearly shown to have acted in bad faith, malice, or gross negligence are, pursuant to the administrative code, solidarily liable to return only the net disallowed amount, which excludes amount excused under the following section 2C and 2D. Now we go to the 2C and 2D. So C, recipients. Whether approving or certifying officers or mere passive recipients are liable to return the disallowed amounts respectively received by them unless they are able to show that the amounts they received were genuinely given in consideration of services rendered. And finally, letter D, the court may likewise excuse the return of recipients based on undue prejudice, social justice considerations, and other bona fide exceptions as it may determine on a case-to-case basis. And so the Supreme Court in this case used the fourth rule to excuse the return of the amount of the scholarship. It said that it cannot be denied that the disbursement was intended to upgrade the quality of the human resource of the NCIP, specifically in terms of further studies and training, and ultimately to improve the efficiency and effectiveness of NCIP in the discharge of its mandate under the law. In the end, the Supreme Court rationated that the ultimate beneficiaries of this funding would be the indigenous peoples who NCIP seeks to serve. The protection of the rights of indigenous peoples carries with it significant social justice considerations, which in turn necessitates the development and empowerment of NCIP's officials, at least insofar as the particular facts of this case are concerned. So in other words, the recipients of the scholarships will have no need to return the amounts that they receive, even though they were actually disallowed by the Supreme Court. The next case involved the Arobo banknote snafu, penned by your bar chair. This is the case of Bangko Sentral ng Pilipinas versus Bohol. The facts are simple. In 2005, the Bangko Sentral ng Pilipinas awarded a contract for the supply and delivery of finished banknotes to FCOF, a French firm engaged in private security printing. The contract was for the production and delivery of 160 million pieces of 100 peso notes, equivalent to roughly 5 million US dollars, and 89 million pieces of 1,000 peso notes, equivalent to more or less 3 million US dollars. FCOF then extended an invitation to BSP to send its representative to witness the production of the printed sheets and approve the same. So, BSP authorized Bool to travel to France as BSP's representative. Bool was tasked to ensure that the printed quality of the printed sheets conformed to the BSP's prescribed specifications for the 100 peso and 1,000 peso denominations before the start of the actual production. Unfortunately, when everything was done, it was discovered that the surname of former President Gloria Macapagal Arroyo in the 100 peso outsourced notes was misspelled as Arovo instead of Arroyo. As such, the BSP formally charged Bool with gross neglect of duty. He was then subsequently adjudged guilty of gross neglect of duty and was meted out the penalty of dismissal from service, with forfeiture of retirement benefits, cancellation of civil service eligibility, and perpetual disqualification from re-employment in the government service. The Civil Service Commission affirmed the decision of the BSP, but the Court of Appeals modified the penalty from dismissal to suspension from office for 1 year. BSP appealed this modification of the penalty. For his defense, Bool claimed that it was his first offense and that his long length of service in the BSP is a mitigating circumstance. The Supreme Court disagreed with Bool. It said that gross neglect of duty is a grave offense under the Uniform Rules on Administrative Cases in the Civil Service, and that the Uniform Rules prescribe the penalty of dismissal from service for gross neglect of duty, even if committed for the first time. Meanwhile, length of service is actually an alternative circumstance that can either be considered as mitigating or aggravating depending on the factual milieu of each case. It is not a magic word that once invoked will automatically be considered as a mitigating circumstance in favor of the party invoking it. The court instructed that in appreciating the presence of mitigating, aggravating, or alternative circumstances to a given case, two constitutional principles come into play which the court is tasked to balance. The first is public accountability, which requires the court to consider the improvement of public service and the preservation of the public's faith and confidence in the government by ensuring that only individuals who possess good moral character, integrity, and competence are employed in the government service. The second relates to social justice, which gives the court discretionary leeway to lessen the harsh effects of the wrongdoing committed by an offender for equitable and humanitarian considerations. In this case, the court found that it was precisely because of Bool's length of service and experience that he was chosen as BSP's representative to France. It was in consideration of his extensive experience, special skills, and relevant expertise that he acquired by reason of his long years of service with the BSP that Bool was chosen for the highly technical work abroad. The fact that Bool had been in service for 33 years should have made him more meticulous and more prudent in discharging his responsibility. Moreover, the offense committed is so gross, grave, and serious in character as to endanger or threaten the public welfare. The repercussions and impact resulting from Bool's negligence in not detecting the error in former President Arroyo's surname are so great as the money spent for printing was put to waste, and worse, PSP and President Arroyo became subjects of ridicule and embarrassment. As such, the Supreme Court affirmed the dismissal of Puol from service. The next case is another one that was penned by your bar chair, docketed as Gatchalian versus Urrutia, dealing with the question of whether a mayor has the power to issue a formal charge and a preventive suspension order against an employee of the Sangguniang Panlungsod for committing sexual harassment acts. For the facts of the case, Mayor Sherwin of Valenzuela City issued a formal charge for sexual harassment with an order of preventive suspension against Romeo Urrutia, Records Officer 4 in the Council Secretariat of the Sangguniang Panlungsod and Chairman of the Board of Directors of the City Government of Valenzuela City Employees Cooperative. The charge stemmed from the complaint of a certain Elizabeth, an on-the-job trainee working in the city government of Valenzuela Employees Cooperative under Urrutia. Urrutia questioned the formal charge and order of suspension before the Civil Service Commission. Urrutia invoked the doctrine of implication in relation to Section 456A, Paragraph 2 of the Local Government Code of 1991, stating that the Vice Mayor's power to appoint officials and employees of the Sangguniang Panlungsod carries with it the power to discipline the same officials and employees absent any contrary statutory provision. He claimed that considering that he is an employee of the Sangguniang Panlungsod and thus appointed by the Vice Mayor, Urrutia said that the act of Mayor Sherwin is an encroachment on the power of the Vice Mayor in violation of the Local Government Code. Is Urrutia correct? Of course not. The Supreme Court held that Mayor Sherwin has the power to issue a formal charge and a preventive suspension order against Urrutia. This was discussed in two levels. First, when Urrutia committed the alleged sexual harassment acts against Elizabeth, he was concurrently acting as the chairman of the board of directors of the City Employees Cooperative, where Elizabeth was an on-the-job trainee, and the staff of the council secretariat of the Sangguniang Panlungsod, which is a position contemplated by the provision that he cited. The court said that these two positions, chairman of the City Employees Cooperative and staff of the Sangguniang Panlungsod, are separate and distinct from each other. Second, the court said that there is an exception to the doctrine of implication expressed in the phrase absent any contrary statutory provision. The general rule is that the power to appoint carries with it the power to discipline. The exception is when the power to discipline or to remove is expressly vested in another office or authority. The exception applies to the case at bar. There is a clear contrary statutory provision expressed in the Local Government Code, which provides that the chief executive has the duty to ensure that the city's executive officials and employees faithfully discharge their duties and functions and cause to be instituted administrative or judicial proceedings against any city official or employee who may have committed an offense in the performance of his official duties. Furthermore, Section 87 of the Local Government Code empowers the local chief executive to impose appropriate penalty on erring subordinate officials and employees under his jurisdiction. Hence, Mayor Sherwin, as the chief executive officer, had the express power to discipline Urrutia as he is under Mayor Sherwin's jurisdiction as the chairman of the board of directors of the City Employees Cooperative. But the court also held here that while the local government code generally applies to the case at bar, the more specific law that applies to sexual harassment violations committed by a government employee like Urrutia is the CSC rules on sexual harassment cases. Under these rules, a committee on the forum and investigation, or CODI, must be constituted in all national or local agencies of the government, state colleges and universities, including government-owned or controlled corporations with original charter. In the absence of a CODI, the head of office or the head of agency shall immediately cause the creation of the CODI in accordance with law and rules. Here, Mayor Sherwin created the CODI, which then found Urrutia liable for sexual harassment. Hence, the mayor, through the CODI, has jurisdiction and authority to try sexual harassment cases even against employees of the Sanggunian. The next case is another unbound case penned by your bar chair. This is regarding the letter of Mrs. Maria Cristina Rocco Corona requesting the grant of retirement and other benefits to the late former Chief Justice Renato C. Corona and her claim for survivorship pension as his wife under Republic Act number 9946. I think everyone is familiar with the facts of this case already, right? But for the benefit of those who are not, here goes. A year after his appointment, articles of impeachment were filed against Chief Justice Renato Corona, and he was eventually indicted by the House of Representatives under Section 2, Article 6 of the 1987 Constitution on alleged grounds of betrayal of public trust, culpable violation of the Constitution, and graft and corruption. After a heavily publicized trial, the Senate impeached Chief Justice Corona and removed him from office mainly due to his act of non-declaration of his Statement of Assets, Liabilities, and Net Worth, or SALN. Having been dishonorably stripped of his public office and having undergone a most difficult and stressful trial, the Chief Justice's health quickly deteriorated, leading to his death. Thus, the separate criminal charges for graft and corruption then pending before the Sandigan Bayan, as well as the tax evasion and forfeiture cases, were all necessarily dismissed in view of the Chief Justice's demise. Now, his widow, Mrs. Corona, wrote the Supreme Court praying that she be allowed to reap the retirement benefits, other gratuities, and monthly survivorship pension. She believes that the late Chief Justice is entitled to these benefits, having toiled for more than 20 years in public service until he was seated at age 63. The Supreme Court granted the pleas of Chief Justice Corona's widow. It explained that the effects of a judgment on an impeachment complaint extend no further than to removal from office and disqualification from holding any public office. Indeed, according to Father Joaquin Bernas, the object of impeachment is not to punish but only to remove a person from office. It is purely political and it is neither civil, criminal, nor administrative in nature. No legally actionable liability attaches to the public officer by a mere judgment of impeachment against him or her. And thus lies the necessity for a separate conviction for charges that must be properly filed with courts of law. In fact, the nature and effect of impeachment proceedings are so limited that Even forum shopping or alleged violation of the right against double jeopardy could not even be successfully invoked upon the institution of the separate complaints or information. The court also held that an impeached public officer whose civil, criminal, or administrative liability was not judicially established may be considered involuntarily retired from service and thus entitled to his retirement benefits. The court explained that whether criminal, civil, or administrative, no court imposed any such liability upon the late Chief Justice. Impeachment is only preparatory to liability, since a removal by impeachment does not explicitly provide for forfeiture as a consequence thereof, as opposed to a criminal conviction carrying the penalty of perpetual or absolute disqualification. An impeached official, like former Chief Justice Corona, cannot be deprived of his retirement benefits on the sole ground of his removal. Such forfeiture could have been imposed upon criminal conviction, which, however, was preempted by his death. So, viewing it in another angle, a judgment of liability in a separate legal proceeding is a resolutory condition after a verdict of ouster by impeachment has been rendered, in that the impeached official retains all the post-employment privileges already earned unless otherwise declared by competent tribunals. Until this liability under the law is so established before the courts, retirement eligibility and benefits that have already accrued to Chief Justice Corona when he was removed by impeachment are due him. There being no such determination of liability, again, his entitlement thereto subsisted. Furthermore, it must also be considered and keep in mind that retirement laws are liberally construed and administered in favor of the persons intended to be benefited, and all doubts are resolved in favor of the retiree to achieve their humanitarian purpose. In this case, the court also had the occasion to again differentiate impeachment from quo warranto, which I think would be super helpful for you guys to memorize. So, while both impeachment and quo warranto seek the ultimate removal of an incumbent government officer, the two differ as to nature, jurisdiction, grounds, the applicable procedural rules, and limitation. Impeachment is political, quo warranto is judicial. In impeachment, the Congress is the prosecutor, the trier, and the judge, whereas quo warranto petitions are instituted either by the Solicitor General in behalf of the Republic of the Philippines or by an individual claiming the public office in issue, both of which petitions are cognizable only by the Supreme Court. Impeachment proceedings seek to confirm and vindicate the breach of the trust reposed by the Filipino people upon the impeachable official, but quo warranto determines the legal right, title, eligibility, or qualifications of the incumbent to the contested public office. The 1987 Constitution, as supplemented by the internal rules of procedure of the Congress, directs the course of impeachment proceedings. Quo warranto cases, on the other hand, are dictated by the rules of court. The end result of an impeachment proceeding is the removal of the public officer and his or her perpetual political disqualification from holding public office. On the other hand, when a quo warranto petition is granted, ouster from office is likewise meted, but the court can likewise impose upon the public officer additional penalties such as reimbursement of costs pertaining to the rightful holder of the public office, and such further judgment determining the respective rights in and to the public office, position, or franchise of all the parties, so the action of the parties to the action as justice requires. So again, impeachment per se connotes mere removal from the post. Impeachment proceedings are entirely separate, distinct, and independent from any other actionable wrong or cause of action a party may have against the impeached officer, even if such wrong or cause of action may have a colorable connection to the grounds for which the officer has been impeached. All right, let's now move on to election law with this en banc case of Marquez versus Comelec. This is actually already the second time that Marquez came to the Supreme Court because the COMELEC keeps on adjudging him to be a nuisance candidate. In the previous case, the Supreme Court held that COMELEC acted with grave abuse of discretion in declaring him a nuisance candidate in the 2019 elections. While he was then victorious in the Supreme Court, it was already too late for him to be included in the ballot. Now, in the present case, he again filed a certificate of candidacy for senator in the 2022 elections. But just like before, the COMELEC Law Department, motu proprio, filed a petition to declare Marquez as a nuisance candidate. According to COMELEC, Marquez has no bona fide intention to run because he is not virtually known to the entire country and that he does not belong to any political party. And by the time that this case was decided by the Supreme Court, the winners of the 2022 elections had already been proclaimed, thus rendering the case moot and academic. But we all know that there are 4 exceptions to mootness. So the court may still consider rendering or may still render a decision if 1, there is a grave violation of the Constitution. 2, the case involves a situation of exceptional character and is of paramount public interest. 3, the issues raised require the formulation of controlling principles to guide the bench, the bar, and the public. And of course, lastly, if the case is capable of repetition yet evading review. Here, the court said that Marquez's situation is one capable of repetition, yet evading review. And the COMELEC, if left unchecked, would be free to deploy all sorts of grounds to declare someone as a nuisance candidate. The court clarified that the grounds cited by COMELEC in this case, that Marquez is virtually not known to the entire country and has no political party to make himself known, are basically the same ground that COMELEC already used against him in the previous case, which is that he had no financial capacity to wage a nationwide campaign. According to the court, the grounds for the disqualification of Marquez in this case are in truth shrouded property qualifications employed by the COMELEC to disqualify an otherwise qualified candidate. In other words, the attempt of the COMELEC to pass off the inability of Marquez to wage an election campaign as an indication of lack of bona fide intent to run for office is unconstitutional and will not be allowed by this court. For what cannot be done directly, cannot be done indirectly. The court also said that COMELEC unfairly shifted the burden to Marquez of proving his genuine intention to run for office. Settled is the rule that he who alleges must prove. Thus, it is the COMELEC Law Department which should adduce evidence in support of its petition to declare Marquez a nuisance candidate, not the other way around. In administrative cases, such as election cases, the burden of proof falls on the complainant. When the complainant fails to show in a satisfactory manner the facts upon which he bases his claims, the respondent is under no obligation whatsoever to prove his exception or defense. To repeat, the burden is upon the COMELEC to prove by substantial evidence that the candidacy of Marquez falls within any of the 3 grounds provided in Section 69 of the Omnibus Election Code to be considered as a nuisance candidate. Finally, the Supreme Court emphasized that bona fide intent is present when a candidate is able to demonstrate that he or she is serious in running for office. Several circumstances belie the COMELEC's conclusion that Marquez did not have any bona fide intention to run for senator. On the contrary, Marquez has been consistently and vigorously asserting his right to be voted for. For on two separate occasions, he sought judicial remedy from the Supreme Court to claim the privilege to run for public office. It is contrary to human experience that a candidate would go through such a rigorous process not once, but twice if he or she has actually no intent to run. Therefore, the Supreme Court here held that again, the COMELEC is mistaken in declaring Marquez as a nuisance candidate. So hopefully, next elections, Marquez would already be able to run. Now let's go to local governments. First up is an unbound case, again, of your bar chair, entitled Meralco versus Muntinlupa, that deals with the validity of a tax ordinance. So, when Muntinlupa was still a municipality, it enacted a tax ordinance in 1994 imposing a franchise tax on private persons or corporations operating utilities within its territorial jurisdiction. Subsequently, RA 7926, Muntinlupa's new charter, was enacted and approved on March 1, 1995, which converted the municipality of Muntinlupa into a highly urbanized city, now the city of Muntinlupa. The transitory provisions of this law adopted all existing municipal ordinances of the municipality of Muntinlupa as of March 1, 1995, and it said there that they all shall continue to take effect within Muntinlupa as of March 1, 1995, unless the Sangguniang Panlunsod enacts an ordinance providing otherwise. Now, in 1999, the city treasurer of Muntinlupa sought to collect franchise tax from Meralco from 1994 onwards. Meralco refused to pay, alleging that municipalities do not have the power and authority to impose and collect a franchise tax, as only provinces and cities do. In resolving this issue, the Supreme Court first enumerated the requirements for a valid ordinance. So, for an ordinance to be valid, it must not only be within the corporate powers of the LGU to enact and pass according to the procedure prescribed by law, but it should also conform to the following requirements. First, must not be contrary to the Constitution or any statute. Two, must not be unfair or oppressive. Three, not partial or discriminatory. Four, not prohibit but may regulate trade. Five, general and consistent with public policy. And six, not unreasonable. Thus, there are two tests in determining the validity of an ordinance. We have the formal test and the substantive test. The formal test requires the determination of whether the ordinance was enacted within the corporate powers of the LGU and whether the same was passed pursuant to the procedure laid down by law. Meanwhile, the substantive test primarily assesses the reasonableness and fairness of the ordinance and significantly its compliance with the Constitution and existing statutes. Here, applying the formal test, the subject ordinance was beyond the corporate powers of the then municipality of Muntinlupa. As such, it is null and void for being ultra vires. The question now is, was this defect cured when Muntinlupa was converted into a city? The answer is no, definitely not. Not even with the transitory provision in the law converting Muntinlupa into a city. This is because a void ordinance is a nullity that produces no legal effect. It cannot legally exist. It cannot have any binding force and effect. As such, Muntinlupa cannot hinge its imposition and collection of a franchise tax on the null and void provision of that tax ordinance. Moreover, the transitory provisions of the Charter of Muntinlupa City cannot breathe life into that invalid ordinance, as the transitory provisions contemplate only those ordinances that are valid and legally existing at the time of its enactment. Here, the subject ordinance is null and void and produces no legal effect from its inception. The next case is another one penned by Justice Hernando. This is Municipality of Corelia versus Philconstruct Development Corporation, dealing with the intricacies of an appropriation ordinance. So Corelia is a municipality in Bohol. Sometime in 2009, Corelia conducted a public bidding for the rehabilitation and improvement of its municipal waterworks system project, and Philconstruct emerged as the winning bidder. Subsequently, Corelia, through the mayor, entered into a contract agreement with Philconstruct for the project for a total amount of somewhere around 15 million pesos. And while the project was ongoing, there was a change in administration and a new mayor was elected. When Philconstruct accomplished more than 50% of the project, it sent progress billings, but the new mayor refused to pay. The new mayor alleged that Corelia's contract with Philconstruct is void as the previous mayor did not secure an authorization from the Sanggunian before entering there too. On this issue, the court said that we must distinguish when a Sanggunian authorization is still necessary to accompany the appropriation ordinance and when it is not. So, depending on the circumstances of the case, if the project is provided for in sufficient detail in the appropriation ordinance, meaning the transactions, bonds, contracts, documents, and other obligations that the mayor would enter into on behalf of the municipality are enumerated, then no separate authorization is necessary. On the other hand, if the project is merely couched in general and generic terms, then a separate approval by the Sangguniang Bayan in accordance with law is required. Jurisprudence also explained that sufficient authority in an appropriation ordinance simply means specifically and expressly setting aside an amount of money for a certain project or program. I am losing my voice here. Excuse me. And in here, the court found that there is no need for a separate authorization from the Sangguniang Bayan, as the appropriation ordinance already identified the project in sufficient detail and not just in general or generic terms. The one-page appropriation ordinance specifically and expressly set aside a specific amount of money for certain projects. The subject appropriation ordinance, having sufficiently covered the project and the cost in detail, need not be accompanied by a prior Sangguniang Bayan authorization any longer. However, there is still another issue. It was alleged that the appropriation ordinance is void because it did not muster the required affirmative vote to pass. The court explained that the general rule, according to the local government code, is that no ordinance or resolution shall be passed by the Sanggunian without prior approval of a majority of all the members present. Remember, of all the members present. But there is an exception to this rule. For ordinances or resolutions authorizing or directing the payment of money or creating a liability, what is needed is the affirmative vote of a majority of all the Sanggunian members, whether present or not. Here, Corelia asserts that the ordinance in question directs and authorizes the payment of money. That's why it's called an appropriation ordinance, and thus requires the majority vote of all the members of the Sangguniang Bayan, not only of the members present. The Sangguniang Bayan of Corella is composed of a total of 11 members, so the majority vote of 6 is required in order for the appropriation ordinance to be valid and binding. However, record reveals that the subject ordinance only obtained 5 affirmative votes based on the quorum on the Sangguniang members present at that time, which was 8 members. And so the appropriation ordinance is null and void. Consequently, the contract between Corellia and Philconstruct is also null and void. But this does not mean that Philconstruct will just swallow its losses. The court held that it may recover based on quantum merit in accordance with the services it had already rendered. This is because Corellia cannot be unjustly enriched and just be allowed to retain the benefits of the services rendered by Philconstruct without properly paying for it. So I guess it's a win-win for the parties, but boo-hoo for the people of Corellia who would not be able to make use of the unfinished waterworks system. Wala, feeling ko lang naman yun. Hearsay from Marites, Your Honor. And now, for our 20th case, for our final topic for public international law, we have none other than Pangilinan versus Cayetano about the Philippines' withdrawal from the Rome Statute. But first, a side note, I observed that there are a lot of obiter dicta regarding general concepts in public international law in this case, particularly on the nature of the sources of law in international law and the supposed hierarchy between them and vis-a-vis municipal law. But since these are obiter, we will stay away from them and just focus on the ratio decidendi of this case. So, brief background. Actually, it's a long background. So, the Rome Statute is a multilateral treaty that established the International Criminal Court where the gravest crimes under international law are prosecuted. Since 1996, under the Ramos administration, the Philippines has participated in the court's establishment, taking an active role in the deliberations as a member of the drafting committee. In 2000, the Philippines, through then-President Joseph Estrada, signed the Rome Statute of the International Criminal Court. President Estrada's act of signing the Rome Statute signified the Philippines' intent to be bound by the provisions of the treaty, subject to the domestic requirements for its validity and enforceability, particularly Article 7, Section 21 of the 1987 Constitution, which requires the concurrence by at least two-thirds of all members of the Senate for a treaty to be valid, binding, effective, and enforceable. In the meantime, on July 1, 2002, the International Criminal Court's Rome Statute entered into force. In 2009, with Senate concurrence to the Rome Statute still pending, then President Gloria Macapagal Arroyo signed into law Republic Act number 9851, otherwise known as the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity. RA 9851 replicated many of the Rome Statute's provisions. Senate concurrence to the Rome Statute was finally obtained during the President Benigno Aquino's administration. On August 30, 2011, the Philippines deposited the instrument of ratification of the Rome Statute. On November 1, 2011, the Rome Statute entered into force in the Philippines. Then on June 30, 2016, President Aquino's term ended and President Duterte took his oath as chief executive. On April 24, 2017, Attorney Jude Sabio filed a complaint before the International Criminal Court pertaining to alleged summary killings when President Duterte was the mayor of Davao City. On June 6, 2017, Senator Antonia Trillanes and Representative Gary Alejano filed a supplemental communication before the International Criminal Court with regard to President Duterte's war on drugs. And then on February 8, 2018, the Office of the International Criminal Court Trial Prosecutor Fatu Bensouda commenced the preliminary examination of the atrocities allegedly committed in the Philippines pursuant to the Duterte administration's war on drugs. However, on March 15, 2018, the Philippines announced that it was withdrawing from the International Criminal Court. The next day, the Philippines formally submitted its notice of withdrawal from the International Criminal Court to the United Nations. On March 17, 2018, the Secretary General of the United Nations received the notification from the Philippine government. And then on May 16, 2018, Senators Francis Pangilinan, Franklin Drilon, Bam Aquino, Laila de Lima, Lisa Ontiveros, and Antonio Trillanes filed a petition for certiorari and mandamus assailing the executive's unilateral act of withdrawing from the Rome Statute for being unconstitutional. Very long background. However, the Supreme Court said that when the Philippines communicated its withdrawal and the ICC's acknowledgement and acceptance of it, the Philippines had already completed the requisite acts of withdrawal consistent and in compliance with what the Rome Statute requires. The petitions were therefore already moot when they were filed, and absent a clear and convincing showing of a breach of the Constitution or a law brought through an actual live controversy and by a party that presents direct material and substantial injury as a result of such breach, the Supreme Court said that it will stay its hand in declaring a diplomatic act as unconstitutional. Nonetheless, it said that the President's discretion on unilaterally withdrawing from any treaty or international agreement is not absolute. So it proceeded to provide guidelines for evaluating cases concerning the President's withdrawal from treaties. First, it said that the President enjoys some leeway in withdrawing from agreements which he or she determines to be contrary to the Constitution or statutes. Example of these are when the courts determine the unconstitutionality of a treaty, the President may unilaterally withdraw from it. 2, the subsequent enactment of a law that is inconsistent with the treaty likewise allows the President to withdraw from that treaty. And third, the court said that even without a judicial declaration that the treaty is unconstitutional, the President also enjoys much leeway in withdrawing from an agreement, which in his or her judgment runs afoul of prior existing law or the Constitution. In ensuring compliance with the Constitution and laws, the President performs his or her sworn duty in abrogating a treaty that, for his or her bona fide judgment, is not in accord with the Constitution or a law. Between this and withdrawal owing to a prior judicial determination of unconstitutionality or repugnance to statute, however, withdrawal under this third basis may be relatively more susceptible of judicial challenge. This may be the subject of judicial review on whether there was grave abuse of discretion concerning the President's arbitrary, baseless, or whimsical determination of unconstitutionality or repugnance to statute. Next guideline. The President cannot unilaterally withdraw from agreements which were entered into pursuant to congressional imprimatur, meaning there was a law passed by Congress mandating the President to enter into a particular treaty. In such a case, the President may not unilaterally abrogate that treaty. This is because the president in this instance is not merely exercising his diplomatic powers, but rather he is in the faithful execution of a law passed by Congress. And the last guideline is that the president cannot unilaterally withdraw from international agreements where the Senate concurred and expressly declared that any withdrawal must also be made with its concurrence. The Senate may do this as effecting treaties is a shared function between the executive and the legislative branches. The Senate's power to concur with treaties necessarily includes the power to impose conditions for its concurrence. The requirement of Senate concurrence may then be rendered meaningless if this is curtailed. In this case, however, the Senate imposed no such condition when it concurred in the Philippines' accession to the Rome Statute. And while there are talks of a subsequent resolution requiring Senate concurrence for the withdrawal, nothing has been passed. So the question now is, what then will happen to the cases filed in the ICC prior to the Philippines withdrawal? The court categorically confirmed that the ICC may still take cognizance of all acts prior to the effectivity of the withdrawal, which is 1 year after the date of receipt of the notification, or all acts prior to March 17, 2019. Exciting, don't you think? So, abangan na lang ang mga susunod na kabanata. Everyone, I think, is watching and looking at developments on this. So that's the last of our 20 cases. I hope that this rundown of recent cases help you in the bar exams. Know that I am praying for your success. Claim your destiny and see you at the oath taking. God bless everyone. Diyos mabalos.
Thank you so much once again, Dean, for that wonderful lecture. Because this lecture was pre-recorded, we won't have time for question. We won't have an opportunity for question and answer during the lecture itself right now. But you may still send in your questions, and we will try to have them answered by Dean. And the answers will just be posted on the social media pages of the Philippine Association of Law Schools. Once again, we still have our labor law on August 11 and legal ethics on August 14. So make sure to follow PALS on their Facebook page to be updated who will be the lecturer and what time the lectures will be. Once again, thank you for attending Caso Discurso.